First, I would like to address Mr. Blandino's written comments submitted to this court. I just want to make it clear for the record that Mr. Blandino is not a volunteer investigator for the commission and never has been. Mr. Blandino can certainly investigate judicial misconduct on his own if he wishes, as do other individuals and organizations throughout this state, and file complaints with the commission. Those complaints have been and will continue to be considered just like any other complaint received by the commission. However, Mr. Blandino is not associated or affiliated with the commission in any respect.
And we'll turn to administrative docket number 582. In this petition, as the petition outlines, again, amendments were submitted for consideration by the legislature through and on behalf of the Nevada Judges of Limited Jurisdiction, but it was a bill that was one of the Supreme Court bills to be considered. It was Assembly Bill 43. The legislature's response was to modify the language of the bill and insert a request of the Supreme Court to study and make recommendations through a commission concerning the procedural and substantive statutes and rules governing the Commission on Judicial Discipline. Further, the legislature requested that we compile statistics and related work of the commission for the legislature's consideration. I coupled this with discussion we've had from time to time with Justice Baragari and others about whether the Article 6 work should be updated, which dealt with the Judicial Code and the provisions of the Judicial Code. We haven't looked at it since 2009. From time to time, I imagine each of the justices, but certainly I have been approached by the members of the bench about consideration of updating or modifications to provisions of the Judicial Code. So both are encompassed within this petition. We have received public comment on this matter as well. That public comment has come from our Nevada judges, Mr. Blandino, let's see here, Mr. Dyla from the Judicial Discipline Commission, and Marc Cook, as well as Attorney Thomas Sheets. So we'll open up public comment on this administrative docket, number 582. Is there any persons in Carson City who would like to offer public comment on this petition for the creation of this commission? All right, and then in Carson City, are there any persons who would like to offer public comment in Carson City? We do have Carson City. Go ahead, Paul.
Oh,
Sorry.
thank you.
Okay.
Put my glasses on. Good afternoon, Chief Justice Hardesty and members of the court. I am Paul Deyhle, General Counsel and Executive Director of the Nevada Commission on Judicial Discipline and Executive Director of the Standing Committee on Judicial Ethics. I only have a few comments at this time, given the limited purposes of this hearing today. First, I would like to address Mr. Blandino's written comments submitted to this court. I just want to make it clear for the record that Mr. Blandino is not a volunteer investigator for the commission and never has been. Mr. Blandino can certainly investigate judicial misconduct on his own if he wishes, as do other individuals and organizations throughout this state, and file complaints with the commission. Those complaints have been and will continue to be considered just like any other complaint received by the commission. However, Mr. Blandino is not associated or affiliated with the commission in any respect. Second, I would also like to briefly address Mr. Cook and Mr. Sheets' written comments submitted to this court. For the record, Mr. Cook and Mr. Sheets were counsel to former Judge Melanie Andrus Tobiasen in a case before the Commission. Their written comments are merely a continuation of their attacks on and onslaught of the Commission and everyone associated with it, as they did before the Commission, this court, the State Bar of Nevada, the press, as well as in the federal court, where they individually sued members of the Commission, staff, investigators, and prosecuting officers. I am not going to get into the sandbox with Mr. Cook and Mr. Sheets, other than to say that the case involving their former client has concluded, and it is simply time to move on. The Commission has done just that. Lastly, the Commission members are literally scratching their heads in bewilderment over all this feigned outrage over how the Commission operates and the manner in which it carries out its duties in addressing judicial misconduct in the state. The Discipline Commission in Nevada is organized and administered in the very same manner as the overwhelming majority of judicial discipline commissions throughout the country, which has been the case since the late 1970s. I was 8 years old when this commission was formed in 1976. Many of the commissioners serving on the commission and many of those participating at this hearing today were likewise much younger at that time. I believe that we can all agree that the processes and procedures of this commission have been in existence for quite a long time. So at the end of the day, what all these attacks and contrived narratives of impropriety concerning the commission really boils down to is rather obvious lack of knowledge of judicial disciplinary jurisprudence and history, and its history. The Discipline Commission is not a civil court. It's not a criminal court. It's not an administrative court. It's not an attorney discipline organization. It is a court of judicial performance as characterized by this court with its own longstanding history, purpose, jurisprudence, rules and procedures, and associated public policy and fiscal considerations. I think it's important to note that as long as we're taking up all our time in attacking the commission and everything and everyone associated with it, we're not talking about judicial misconduct, which I believe is the intended objective by some, not all. And it is judicial misconduct that concerns the citizens of this state the most. I can say unequivocally that the citizens, including even members of the judiciary and the bar, want a strong judicial discipline commission. Nevertheless, as I stated in the commission's written comments to this court, there are reasonable proposals to consider on behalf of the commission, the judiciary, the bar, and the public. The commission looks forward to participating during this process and to professional and honest dialogue concerning issues facing all parties over the coming months and year. Thank you, and I'd be happy to answer any questions that you may have.
Thank you, Mr. Dyla, for being available today. Any questions from any members of the court? Seeing none, I don't see any any questions for you, Mr. Dyla. Thank you.
Thank you.
Are there any other persons in Carson City who wanted to offer public comment today? Okay, are there any persons in Las Vegas who would like to offer public comment on this administrative docket petition?
Good afternoon. Again, for the record, my name is Judge Ann Zimmerman. This time I'm appearing on behalf of the Nevada Judges of Limited Jurisdiction as President-elect, and we do support the creation of this commission. And that's really all I want to say, is to put on the record that the NJLJ does support the creation of this commission.
Okay, thank you, Judge.
I would also like to add that I hope that if the commission is created, that you include a seat for attorneys who represent the judges in these matters. Okay?
Thank you.
Thank you.
Any questions for Judge Zimmerman? I see none. Thank you, Judge. Any other persons in Las Vegas who would like to offer public comment?
Chief Justice, my name is Marc Cook. I believe I've recently been mentioned. I was not a party to any action. I do, as Judge Zimmerman just noted, I have represented at least a judge before the commission. My comments I submitted in writing, I'm not going to repeat them. They weren't attacks. They weren't personal. They're concerns. I did not view your petition, Justice, as to be something to allow judges to get some kind of ethical out where they get to escape. I understood the petition to be an examination of the rules for transparency and consistency, and I believe that's appropriate. In reviewing some of the responses that were against it, in particular Mr. Dyla's, one of the things I read was that we've had these rules for a long time and we looked at this before, and so why look at it again? And first, because it's been, I think, 12 or 13 years. Second, during the 2019 Ways and Means Commission, where the Judicial Commission was asking for more money, one of the things they commented on in 2019, which is before I came along, it's not my fault, was for about a year and a half before that meeting, they had had an increase in appeals and writs and emergency motions. So that takes us to about the fall of 2017. During the March 2021 meeting on the same topic, that evidently, per Mr. Dyla, who testified, and I can give you the timestamps from both of those meetings if necessary, he repeated that concern of the increased appeals, writs, and emergency motions. If they've been increasing over the last 4.5 years, I think that is just one more reason that justifies taking a look at these rules to make sure they're applied consistently, the attorneys representing the judges are reading these the same way that the commission is, and that there's some level of clarity. I think it not only makes sense for transparency and consistency, but it makes for better judges, which is, I don't know anybody, the people who are most critical of bad judges are the good judges. And this will allow a system where we can take a look at it and make sure the rules are consistently applied. And based on the last two requests for more money by the JDC, I think it's also more fiscally responsible to tighten these up so we perhaps don't have the same level of writs and appeals and emergency hearings. And with that said, I don't want to repeat anything I put in the writing, so unless you have any questions, I'll sit down.
Any questions for Mr. Cook?
By the way, I would volunteer for the committee if requested.
Thank you, Mr. Cook. I appreciate your presence today. Hi, good afternoon.
Good afternoon. Good afternoon, Chief Justice and Justices. My name is Sigal, Chattah, and I'm also here to testify on behalf of, in support of A.D.K.T 582. One of the things that I want to advise this court before I proceed into my actual transcript and my speech that I prepared is that what I will be testifying on is based on communications that myself, colleagues in the legal community, and also clients have had concerns that I believe can be addressed with the creation of this commission. And the rules as they are codified in the judicial canons are really the tenets that promote confidence by the public, not only in the judicial commission, but also the bench. And one of the issues that we have is that there is a public perception that there are some judges that are protected more by the JDC and others that aren't. And one of the issues that has consistently come up among certain attorneys is there's some judges, like I said, that are protected. And what we see is that litigants that are in front of a judge that we believe is protected, that these litigants know that no matter what this judge does on the bench, no matter how they rule, whether there's a competency issue and whether there are issues concerning these rulings, that there's no redress. And the opposite side of that is that we know that there are judges that are extremely good judges that, because of the arbitrariness of how the JDC has applied certain rules, that these judges are nitpicked and their actions are picked apart. As with all administrative bodies in our state, there is perfection and there's imperfection. And what I would like to do is I would like to bring to attention some issues that I believe need to be reviewed. And I believe that a commission would be the perfect way to review these issues. One, Mr. Crook said transparency. As an attorney, I served with the Committee on Ethics and Discipline for 12 years with the State Bar. And I think that it is quite baffling that our judges aren't afforded the same rights and the same procedures that lawyers are. In the State Bar of Nevada, we have a 2-panel system. One of the preliminary issues that we deal with, there is a panel of 3 members that is comprised of attorneys and lay members, and that panel decides whether there is sufficient evidence to proceed with a disciplinary factor. Once that disciplinary issue is then determined, then we have a completely separate panel that adjudicates that discipline and takes evidence and testimony on that discipline. That does not exist with the JDC. With the JDC, what we have is we have one person that acts as a grand jury, acts as the person that selects the investigators, acts as the person that selects the prosecutor, and acts as the final determiner and the final adjudicator of discipline. And that is very scary for judges. That is baffling that judges are subject to that, just because we have to have this due process separation that, like I said, if it's good for attorneys, why wouldn't it be good for the judges? I have additional comments here that there's certain procedural defects. There's a conflation of what the standards of review are, as opposed to the standards of proof to bring the formal charges. So is the standard of review a reasonable probability that the panel will have clear and convincing evidence to discipline the judicial officer, or is it a 2-part standard? So there's these issues that we have are really, this is why it's necessary for the commission to review not only the standards of proof at the time, because we know that we have clear and convincing to adjudicate a discipline, but to file the formal charges, we have reasonable probability. So I think that needs to be addressed. I think also one of the issues that I see with the rules now that we have with lawyer discipline is I don't see sets of aggravating factors, mitigating factors. The Supreme Court reviews attorney discipline all the time. And when an attorney is suspended or if an attorney is disbarred, these are things that you guys get to see when we issue, or when I did issue, suspensions or any other type of misconduct issues. Now, I will submit the rest of my notes, but I think that I've given a couple of examples where it's necessary to start a commission. The purpose of my testimony is not to rewrite the rules. I don't think that that's what we're doing today, as the Chief Justice said, but I do think that when we do have a commission that investigates the rules and policies of judicial discipline, it does instill public confidence, both, like I said, in the judiciary and in the Judicial Commission. And with that, thank you. Defer to the court for any questions.
Any questions for counsel? Thank you for making the time to be here. And yes, I invite you and anyone to submit your written comments to supplement your statements.
I will. Thank you.
Yes. Anyone else in Las Vegas who would like to speak on this topic?
Alexander Falcone, Administrator of our Nevada Judges. I just have some notes on my phone. I've already provided written comments, but I did want to give some analytics from the public who've observed our comprehensive coverage of the Commission on Judicial Discipline's proceedings. For the year 2020, we had 10,892 citizens observe the proceedings from beginning to end, with a total of 193,919 watch time minutes. Approval
Mr.
by the,
Falcone, sorry, can you slow down and get
Oh,
closer to
sorry.
the mic?
not used to this, with a approval rating of 98.07%. And that's all I have to add.
Okay, thank you very much for being present today. Any questions for Mr. Falcone? All right, thank you, sir. Anyone else who would like to offer a public comment to the court on this administrative docket? All right, seeing none, this administrative docket number 582 will also be submitted for the court's determination and deliberation. I'd like to thank all of you for taking the time to come to the courthouse here and in Carson City to offer your input. And I'd like to thank those people who offered written comments. We're very much appreciated. We'll be in recess. Thank you.